Good afternoon, everyone. Thank you so much for joining us today for the first in the National Sea Grant Law Center summer webinar series to highlight the research results from our collaborative project on legal barriers and challenges to shellfish aquaculture in the United States. Today, we're focusing on sharing the results from two of our case studies that we did here at the National Sea Grant Law Center, Nationwide Permit 48 and the Endangered Species Act. But before we get started, I just wanted to give a little bit of background on the project. So for those of you who don't know me, I'm Stephanie Otts. I'm the director of the National Sea Grant Law Center. We're based here at the University of Mississippi. This was a large collaboration among a variety of Sea Grant programs, including Rhode Island Sea Grant Legal Program at Roger Williams University School of Law, the Virginia Coastal Policy Center at William and Mary Law School, the Carl Vinson Institute of Government at the University of Georgia, and the California Sea Grant Program. And throughout the summer and the different webinars, you'll be hearing the results of each of their projects. So this project was funded by NOAA Sea Grant in 2017, and the overall project objectives were to identify priority law and policy barriers to expansion of shellfish operations in coastal communities around the country, to conduct legal analysis and research on those barriers that were identified, and then to implement outreach programming related to that. So we're now in the outreach phase. We have identified, produced 6 case studies eight case studies related to this project, and that's what we'll be hearing about today and throughout the summer. And we also have a project webpage for the project. And so if you're interested at all about learning more about this project, we encourage you to visit the National Sea Grant Law Center's website and learn about this project specifically. And with that, I want to turn it over to our National Sea Grant Law Center staff attorneys, Catherine Janessi and Amanda Nichols, who will be talking about their case studies.
Done on this case study was done in late 2017 and early 2018, as this case study was one of the first that was published as part of the Shellfish Project. So anything after that is not contained within this case study or this presentation. And just to give you a little bit of a rundown of what I will be presenting on during this presentation, first of all, I will give everyone an introduction to the permitting structure that governs shellfish aquaculture as per the Army Corps of Engineers, which is the permitting structure that my case study deals with. And then I'll give everyone a brief summary of Nationwide Permit 48, as well as a little bit of explanation into the controversy behind the 2017 reissuance. And then finally, I will go into a discussion of remaining legal barriers to shellfish aquaculture that still exist despite the favorable language of Nationwide Permit 48. So just to get started with this introductory material here today, some of the federal laws governing nearshore shellfish aquaculture, the two that we're concerned with today are firstly, the Clean Water Act. Section 404 specifically gives the Corps regulatory authority over activities involving the discharge of drill and fill materials into navigable waters. And Section 404 prohibits that discharge into waters of the United States without a Corps permit. Secondly, the Rivers and Harbors Act, specifically Section 10, prohibits the obstruction or alteration of navigable waters in the United States without a Corps permit. And it's important to note that the Corps has combined these permitting processes for the Clean Water Act Section 404 and the Rivers and Harbors Act Section 10, and that combined process is what we're dealing with today. It's also important to note, however, that aquaculturists have to comply with other federal permitting frameworks, such as the Endangered Species Act Act and the National Historic Preservation Act, but those are just not the focus of this case study. So really just the Clean Water Act and the Rivers and Harbors Act. Now a little bit of background information into that permitting scheme in general that is administered by the Corps for shellfish aquaculture. So the Corps will issue two different categories of permits, the first being individual or standard permits, and the second being general permits. These two categories of permits differ in one main way. Individual permits are issued when there are thought to be significant impacts to wetlands, streams, and other aquatic resources associated with a proposed project, while general permits are issued when there are thought to only be minimal individual and cumulative impacts. A few more facts about the individual permits. They are regionally specific. They can also be more expensive and time consuming, and this is because they require a case-by-case evaluation and also the submission of detailed documentation regarding the project scope, design, construction, and operation. On to general permits, there are three subtypes of these. The first being nationwide permits, the second regional general permits, and the third programmatic general permits. And it's important to note that not all 38 districts use all types of general permits, and some districts have implemented regional restrictions or conditions to those permits. A little bit of information in general about nationwide permits. This is just general information, not specific to Nationwide Permit 48. But nationwide permits authorize activities on a national level. There are currently 54 of them, and they are renewed and reissued every 5 years for updates and to provide clarity and certainty for the public while protecting the aquatic environment. And the most recent renewal was finalized in March of 2017. These nationwide permits have varying applicability due to a number of factors. The first one being that Corps district commanders have the power to revoke a nationwide permit in a state or other geographic area for various reasons, including due to potential adverse environmental impacts that a proposed project could cause. States also have some authority to prohibit the application of nationwide permits, as we'll talk about a little bit later. And so exercising limiting authority in these ways can result in a patchwork of nationwide permit coverage across the many districts and states. So just because a nationwide permit exists doesn't mean that it actually applies in any or all districts. Regional general permits are like nationwide permits, but they only apply within a specific geographic area. These permits are proposed by districts, and the application procedures for them vary from place to place. Just by way of example, in the Baltimore district, they have implemented an RGP entitled RGP-1 in 2011, which regulates new commercial research and educational bivalve shellfish aquaculture activities in Maryland tidal waters. And that RGP provided a more streamlined authorization process for some oyster aquaculture activities. However, that permit has since expired and been replaced with the 2012 language of Nationwide Permit 48, in addition to several regional conditions. Now, programmatic general permits, or PGPs, are unlike nationwide permits or regional general permits in that they are based on existing state, local, or other federal programs and are designed to eliminate redundant Corps and state regulatory efforts that provide similar protections to aquatic resources. And in some states, PGPs have replaced some or all of the Corps' NWPs, which can result in greater overall efficiency in some instances. So, for example, in the Jacksonville district, they have implemented SAJ-71, which authorizes the deposition of materials for live rock aquaculture within federal waters off the Florida coast. And this permit is administered by the National Marine Fisheries Service through an operating agreement with the Corps that gives it general authority to administer the permit. So one can see how this is a more efficient process in some cases. Now on to the meat of why we're really here today. Nationwide Permit 48. So Nationwide Permit 48 briefly authorizes commercial shellfish aquaculture activities that are predicted to have minimum individual and cumulative impacts. It also authorizes the installation of equipment and discharges of dredged or fill materials into waters of the United States. Some of the controversies surrounding the 2017 reissued version of Nationwide Permit 48 centered around its delineation between new and existing commercial shellfish aquaculture operations. So the 2017 version of Nationwide Permit 48 promulgated a new definition of new operations, which means new operations now are considered those where shellfish aquaculture activities have not occurred at any point during the last 100 years. So an operation would be existing if any aquaculture activity has occurred there in the last 100 years. And this occurs, this matters because of pre-construction notification, or PCN, which is additional information submission requirements that are required for new operations. Existing operations do not submit PCN unless the aquaculture that they are proposing will include a species that's never been cultivated in the body of water in question. And this spurred controversy because of the potential outlying situations that could occur if we go strictly by what the reissued language of the 2017 version of Nationwide Permit 48 says. So for example, an existing operation could be one, just hypothetically, that may have been used for aquaculture, say 75 years ago, and only in 1 square acre. And then aquaculture halted in that parcel up until present, when someone is trying to again do aquaculture on that parcel. So really there's been controversy about whether it makes sense to let those outlying situations proceed because of the practicality considerations. But it's important to remember that submitting documentation to prove that a site actually is existing may be onerous or impossible in a lot of those outlying instances. And this is because it's hard to locate evidence of property surveys that existed in decades past, or other evidence that you would need to show to prove that a site is actually an existing site. It's also important to note before we move on that Nationwide Permit 48 is not applied uniformly throughout all U.S. states. Just as I mentioned in the background information, with the general nationwide permits, they can be approved, conditionally approved, or completely denied depending on where you are. For the remainder of my time, I'm going to explore some of the remaining legal barriers to shellfish aquaculture despite the favorable language and expeditious process that Nationwide Permit 48 fosters. So the first of these have to do with state review of core permits. Section 401D of the Clean Water Act sets forth certain water quality certification requirements that note applicants for a federal license or permit must provide certification from a state that any discharges will comply with state water quality standards and other applicable state authorities. So states can approve, condition, or deny this Section 401D certification. And if denied, the federal agency may not issue a license or a permit, preventing an aquaculture site from going into operation potentially, even if they have obtained all of their other permits and are great in every other respect. So the CZMA federal consistency provisions are similar to that. Section 307 of the CZMA requires that federal actions, including federally permitted activities that have reasonably foreseeable effects on any coastal use or natural resources of the coastal zone, be consistent with the enforceable policies of a state's federally approved coastal management program. This is what's known as federal consistency. So states can choose to approve, condition, or deny federal consistency, and states approving a federal permitting activity will grant what's known as a concurrence. But if a state declines to grant a concurrence, the federal agency is prohibited from issuing the permit, meaning that an aquaculture farm could not begin operating again, even if they had all of their other ducks in a row. Just by way of example here, Mississippi has declined to grant a concurrence for any nationwide permits located in several listed categories of waters, and requires applicants wishing to conduct aquaculture activities in those waters to first contact it for authorization. So if the Mississippi Department of Marine Resources declined to provide a concurrence, an aquaculture project could be prohibited from operating in the state, even if that project otherwise qualifies for authorization under a general permit. So we can see how hangups can come about despite the existence of Nationwide Permit 48. Another category of potential barriers here have to do with regional and state implementation. So as I mentioned a little bit earlier, district commanders in the Corps have a revocation power when it comes to nationwide permits. For example, the New England District of the Corps has fully suspended nationwide permits and replaced them with general permits in each state. So it doesn't matter how familiar you are with federal core permits at that level. It depends on how familiar you are with district permits and those processes. States also have a limitation power. They have a broad authority to enact laws and regulations to protect natural resources, as well as an authority to develop leasing program for shellfish aquaculture. So some of these laws may be helpful and oftentimes are, but some may also pose barriers. For example, in Connecticut, the state has implemented certain buoy placement guidelines that were established by the state Department of Energy and Environmental Protection's Boating Division, and these buoy placement guidelines are meant to protect boaters and prevent accidents. But the Corps has implemented separate marking guidelines for shellfish aquaculture sites, and if a site follows one of these and not the other, for example, they could experience a delay and be held up on the back end from beginning operations, even if everything else is great with their permit and whatnot. Finally, the last category of barriers here have to do with legal challenges. As one might expect, these, if successful, can also pose significant problems to beginning operation of aquaculture sites. I've put up 2 pending legal challenges here for y'all to see, as well as their docket numbers, so you can go and read the complaints if you would like. As of a few days when I checked, these are both still active cases, and they both have to do with Nationwide Permit 48. So I will just briefly kind of go through what the parties are alleging in these complaints. In the first one, the Center for Food Safety's complaint against the Seattle District of the Army Corps, a little bit of background information of that is that when the 2017 version of Nationwide Permit 48 was issued, the Seattle District of the Corps chose to implement only one regional condition after it approved the permit, and this had to do with prohibiting the commercial harvest of clams by hydraulic escalator. Well, when the Center for Food Safety found this out, they filed a legal complaint arguing that Nationwide Permit 48's revised definition of a new operation would allow shellfish aquaculture acreage in the state to double to an estimated 72,300 acres, constituting 1/3 of the state's shorelines. And this is an increase in acreage that the Center for Food Safety said would increase any negative environmental impacts that shellfish aquaculture could have on the state's coastlines. The Center for Food Safety also asserts in their case that the Corps did not fully consider the environmental impacts of Nationwide Permit 48 in a way that violated the Clean Water Act, NEPA, and the APA. They're arguing that the district should have imposed additional regional conditions to mitigate environmental harm above and beyond that one related to the harvest of clams by hydraulic escalator. So the Center for Food Safety wants the court to vacate the Seattle District's decision regarding Nationwide Permit 48, which, as one might expect, could severely impact aquaculture in the state if this case is successful. And moving on to the second complaint here, filed by the Swinomish Indian tribal community against the Corps, federally, the Seattle District, and the National Marine Fisheries Service, or NIMFS. So the parties representing, well, the Swinomish Indian tribal community here takes issue with Nationwide Permit 48's inadequate protection of eelgrass, which the Seattle District, in the Swinomish Indian tribal community's opinion, failed to mitigate by imposing regional conditions to Nationwide Permit 48 above and beyond, again, that one condition. So the tribe wants to have the court vacate and set aside Nationwide Permit 48 as applicable to native eelgrass beds in North Puget Sound. So again, the outcome here could also create significant challenges for aquaculture stakeholders in successfully permitting and operating shellfish farms if successful. So important to keep an eye on legal challenges. Maybe specifically these 2 would be good to keep an eye on as well. And with that, I would just like to conclude kind of by saying that Nationwide Permit 48, as exemplified by the presence of these existing legal barriers, despite its favorable language, is not always the final answer for shellfish aquaculturists. And as a result, those aquaculturists should be aware of the limiting factors that are imposed by core districts and states on both the front and the back ends in order to have the best chance of getting their operations up and running as quickly and efficiently as possible. And with that, I'm going to hand it over to my colleague, Kathy Janesy, who's going to present to you all today on the Endangered Species Act and the Red Knot. Thank you.
All right, Thank you, Amanda. And just as a housekeeping note, we're going to do questions at the end of both of our presentations. So if you had a question based on Amanda's presentation, you can put it in the chat box now, and we will address those questions again at the end of both of our presentations. So I'm Kathy Janessi. I'm here today to present my case study, which focused on the Endangered Species Act, and in particular, the impact of the listing of the red knot on oyster aquaculture operations in New Jersey. So the Endangered Species Act can present a regulatory hurdle for both new and established aquaculture operations. If a species is already listed in the area, a prospective farmer may have trouble securing the necessary permits and approvals needed to get a farm up and running due to the potential impacts on the species in question. And the ESA can also have implications for established operations and if a species is newly listed in the area. As I mentioned, in New Jersey, the listing of the red knot has already impacted aquaculture operations in the state. However, the Act's terms and how the different sections work together can be confusing for those who are unfamiliar with the Endangered Species Act. So using the red knot case study as an example, I want to give a broad overview of the ESA today, including its purpose, its listing and critical habitat designation process, and its consultation and take provisions. So the red knot was the subject of a project I worked on with New Jersey Sea Grant. The red knot is a little shorebird weighing less than a cup of coffee, and it's truly a master of long-distance aviation. On wingspans of 20 inches, red knots fly more than 9,000 miles from south to north every spring, and repeat that trip in reverse every autumn, making this bird one of the longest distance migrants in the animal kingdom. About 9 inches long, red knots are among the largest of the small sandpipers. The lower Delaware Bay shoreline in Cape May County, New Jersey, serves as the center of a recovering oyster aquaculture industry with historic roots. Contemporary oyster farming is a relatively small but growing industry. In 2016, 19 farms sold over 2 million oysters with a farm gate value of around $1.4 million. Structural aquaculture uses gear to contain seed oysters as they are raised for cultivation purposes, and these structures, including rebar racks, mesh bags, cages, and floats, all need permits from the U.S. Army Corps of Engineers and the state of New Jersey. Now, to promote the development of oyster aquaculture in New Jersey, the state developed an aquaculture development zone in the mid-2000s. The ADZ is intended to ease permitting burdens on potential oyster farms and locate farms in areas with the few issues complex. The ADZ is meant to streamline the permitting process for farmers as the New Jersey Bureau of Shell Fisheries obtains the necessary permits from the Corps and relevant state agencies on behalf of the individual growers. So in addition to being home to the oyster industry, Delaware Bay is also an important stopover location for migratory shorebirds, including the red knot. The red knot's listing as a threatened species on the Endangered Species Act has already impacted the oyster industry. And in particular, concerns have emerged about how structural oyster aquaculture will affect the red knot and a major knot food source, horseshoe crab eggs. So the Endangered Species Act was passed by Congress in 1973 with only 4 no votes and is administered by the U.S. Fish and Wildlife Service and the Department of Interior for terrestrial species and by the National Marine Fisheries Service and the Department of Commerce for listed marine species. Congress passed the ESA to protect both imperiled species and their ecosystems, declaring that the Act's purpose is to provide a framework that conserves the ecosystems upon which endangered species and threatened species depend, and establish a program for the conservation of such species. Conservation is defined to mean to use all of the methods and procedures which are necessary to bring any endangered species or threatened species to the point at which the measures provided pursuant to the chapter are no longer necessary. Thus, the ultimate goal of the Act is to recover a species to the point where the protection of the Act are no longer necessary. And I have here just as a note to keep in mind as we're talking about the red knot and the process that's happened so far in New Jersey is that any uncertainty is decided in favor of the species under the Act. So if there is a gap in the science, the agency must take actions to protect the species. So now I'm going to move through these different main sections of the Act. And so the first of these is the listing process and the designation of critical habitat. Just briefly, I wanted to cover the definitions that are involved in this section, just so we know what we're talking about as we go through the process. So an endangered species is any species which is in danger of extinction throughout all or a significant portion of its range, except for pests. A threatened species is any species which is likely to become endangered within the foreseeable future. And then critical habitat can be areas that are either inside and or outside the current habitat for the species. And these areas are supposed to have the physical or biological features that are essential to the conservation of the species, and which may require special management considerations or protection. So Section 4 of the Act lays out how a species can be listed as either endangered or threatened under the Act. A species can be listed either by the action of the agency on its own or pursuant to a public petition. Recently, there have been mega petitions filed by conservation groups to hold the agencies to the listing deadlines mandated by the Act, most notably the 12-month finding deadline that you can see on this chart. This has led to settlements involving hundreds of species, which is one of the reasons so many listings have been happening in recent years. Just wanted you to note also that if a listing is warranted but precluded, the species goes on what is known as a candidate species list to be reevaluated in the future. So in making listing determinations, the Secretary must only consider the best scientific and commercial data available. So notably, the economic impact is not to be taken into account at this stage. And when making listing determination, the Act directs the Secretary to take several factors into account, including whether the species habitat or range is presently or threatened to be destroyed, modified, or curtailed, or if the species is being overutilized, among other factors. So for the red knot, the Fish and Wildlife Service began to receive petitions to list the species starting in 2004, and the agency received additional petitions in 2005 and 2008. The Fish and Wildlife Service finally determined to list the red knot as a threatened species pursuant to a 2011 settlement agreement between the agency and the Center for Biological Diversity. The listing became effective on January 12, 2015. Now, once a species is listed, the Act directs either the Fish and Wildlife Service or NIMS to designate critical habitat, which again are these areas that are essential for the conservation of the species. But it cannot usually occupy their entire geographical area. So those agencies can't say, this is everywhere that species can live, that's all the critical habitat. You should know that economics can be taken into account for designated habitat. Provide greater protection to the species. Altering habitat can be based on restriction and habitat also must be considered of the species. A lot of energy is in critical habitat for life sources. There are many species that
Right, I know we're having some audio issues. If people could chat and see if they can hear now. Yeah, that's better. So yeah, we'll switch, but you'll have to move over to mine. Sorry about this, folks. Good. Yeah.
Sorry about that. I'll start by going over this slide again.
Yeah.
Okay. Right, so critical habitat is designated on the basis of the best scientific data available. And so, as I note here, at this point in the time, the agencies can consider the economic impact of critical habitat designation while they couldn't do so under the listing process. Critical habitat provides greater protection to the species. So altering critical habitat contributed to a take under Section 9, and altering habitat also must be considered in Section 7 consultation. And then Though the plain language of the ESA mandates the designation of critical habitat by Fish and Wildlife Service or NIMS, there are many species protected by the ESA for which critical habitat has not been designated. So the Fish and Wildlife Service has not designated critical habitat for the red knot, and in fact, critical habitat has not been designated for any listed species in New Jersey. Thus, the additional protections afforded to a species through the designation of critical habitat is not yet available to threatened red knots or many other species. So the next section of the Act that I want to cover is Section 7 consultation, which is the focus of the red knot case study and caused the most amount of controversy around the red knot listing. So Section 7 applies to the actions of federal agencies and aims to ensure that any proposed action by the agency is not likely to jeopardize the continued existence of any endangered or threatened species or result in the destruction or adverse modification of critical habitat. So in essence, the provisions are meant to prevent the federal government from putting a listed species in jeopardy of extinction. So once consultation is initiated, the ESA prohibits any reversible or irretrievable commitment of resources with respect to agency actions. And during the process, the agency proposing the action agency works with the expert agency, either Fish and Wildlife Service or NIMS, to determine whether its action will jeopardize the species or adversely modify its habitat. So there are some parameters for when Section 7 applies. Section 7 only applies to federal actions, which are actions authorized, funded, or carried out by the federal government. And further, consultation only applies to actions in which there is a discretionary federal involvement or control. Although the consultation requirement applies to all listed plant and animal species and all designated critical habitat, the section only requires consultation if a federal action will jeopardize the species as a whole and not simply individual members of the species. Again, the action agency must provide the best scientific and commercial data available in order for the expert agency to have an adequate review of the effects that an action may have upon a listed species or critical habitat. And just quickly, I wanted to highlight what that jeopardy prohibition requires. So the phrase jeopardize the continued existence of a species is known as the jeopardy prohibition. It is defined in regulation to mean to engage in an action that reasonably would be expected, directly or indirectly, to reduce appreciably the likelihood of both the survival and recovery of a listed species in the wild by reducing the reproduction numbers or distribution of that species. So the potential impacts of a proposed federal action on a listed species or its habitat is assessed through an administrative process known as consultation. Consultation is a two-step process. So it involves both an informal and formal consultation. Informal consultation is an optional process that can be used to determine whether formal consultation is needed. If any listed species are present in the area of the proposed action, and it is possible that the proposed action may adversely affect the listed species or its critical habitat, then formal consultation is required. If formal consultation is needed, the appropriate expert agency will produce a biological opinion or BIOP. The BIOP will consider if the action and its cumulative effects are likely to jeopardize the continued existence of the listed species or result in the destruction or adverse modification of critical habitat. If the answer to this question is yes, the expert agency must formulate reasonable and prudent alternatives that can be implemented by the action agency to avoid jeopardizing species or harming its critical habitat. Now, once the expert agency issues a biological opinion, the consultation process is ended. If no jeopardy is found, the project may advance. If the activity will result in some take of the species, the biological opinion likely will include an incidental take statement, as I will discuss later. And if the BIOP contains a jeopardy determination, the action agency has three options. It can terminate the action, it can implement the reasonable and prudent alternatives, or it can seek an exemption from the cabinet level Endangered Species Committee, also known as the God Squad. Now, importantly, the scope of the biological opinion is limited to the proposed agency action, and I had to note this quite a bit while working on the Red Knot project. While there may be multiple stressors on a listed species survival, the BIOP can only address actions under the control of the permitting agency. For example, if agricultural runoff is harming a listed species habitat, but the action agency is the Corps issuing a permit for an aquaculture farm, only the impacts from the farm are considered in the BIOP, as the expert agency has no authority to dictate action for another agency not party to that BIOP. So as required by the ESA, the Fish and Wildlife Service, as the expert agency, developed a biological opinion for structural aquaculture operations in portions of the Delaware Bay in New Jersey for the Corps, which was the action agency. The consultation was triggered by the issuance of permits by the Corps to the state of New Jersey for structural aquaculture in the AD area. The BIOP considered the potential impacts on the threatened red knot by the Corps' permits, and only the permits for the reasons I discussed above. So the red knot BIOP is programmatic, meaning that this initial BIOP looks at the overall course program for certain ADZ areas in Delaware Bay, and then the Fish and Wildlife Service and the Corps will engage in streamlined consultations as individual permits for farmers are needed under the program. The BIOP found that the Corps' permits would not result in jeopardy to the birds. The BIOP split the action area into two portions. So the southern segment already has established aquaculture operations and better physical attributes to host aquaculture. Thus, the BIOP dictates that in this area, aquaculture will be clustered, facilitated, and expanded, recognizing that there will be localized adverse effects to the red knots. The northern segment has more concentrated red knot use and low aquaculture use. Thus, the BIOP prioritizes red knot conservation and recovery in this portion of the action area, in part to compensate for the farms in the southern segment. The BIOP does require certain actions that the aquaculture farmers must take, known as conservation measures, to reduce the potential harm of oyster farming on the red knot population. The BIOP says that these measures are non-discretionary actions that aim to benefit or promote the recovery of the red knot and are an integral part of the proposed action and serve to minimize or compensate for project effects. Among other things, the conservation measures limit gear placement to reduce the impact on horseshoe crabs, and as well as farm hours and access to the farms to help reduce the impact on red knot behavior. These conservation measures have already resulted in the closure of at least one farm site, potentially impacting others. So finally, the conservation measures provide for an adaptive management process that I will discuss in a few minutes. But the BIOP is like a lightning rod for conflict between the aquaculture community and the shorebird conservation groups. The industry is really concerned that these measures are not necessary to protect the birds. And they assert that oyster farms and red knots interactions are minimal as the farms occur along less than a mile of the roughly 100-mile Delaware Bay shoreline that red knots frequent. And further, buffers around farms are in place to enhance red knot protections. But on the other hand, red knot scientists and non-governmental organizations are concerned that the measures in the BIOP are not even enough to help protect the birds. And so some of these organizations have even petitioned the state and federal agencies to stop aquaculture growth and control existing activities further out. I'm concerned that the farm gear and activities may disturb red knots along lower bay beaches during their annual spring migration. So finally, quickly, I just want to go over the take provision, what it means to actually take a listed species under the Act. So while all endangered species are covered by the take prohibition, threatened species are not. The Fish and Wildlife Service has adopted a blanket rule that extends ESA take prohibition to all threatened species unless the agency adopts a species-specific rule, removing all or part of that blanket take prohibition. NIMS does this on a case-by-case basis. Since the red knot's a terrestrial species, through that Fish and Wildlife Service rule, the take prohibition applies to the threatened red knot. Now, the take prohibition applies to any person subject to the jurisdiction of the United States, including businesses and governmental units. And with take, finally, we are concerned with individual members of the species. So just an effect on one red knot can equal a take under the Act. And just note that take only applies to wildlife and not to plant species. So the ESA defines take to mean to harass, harm, pursue, hunt, shoot, wound, kill, trap, capture, or collect, or an attempt to engage in any such conduct. Both lethal and non-lethal actions can constitute a take under the statute. And the agencies have defined both what harass and harm mean through regulatory action to include activities that interrupt a creature's essential life functions of breeding, feeding, or sheltering. So harass means an intentional negligent act or omission, creating a likelihood of injury to wildlife to such an extent that it's disrupting normal behavioral patterns, including breeding, feeding, or sheltering, while harm is an act which actually kills or injures wildlife, and that can actually include significant habitat modification or degradation if it's killing or injuring the wildlife by impairing those essential behavior patterns. Therefore, take includes many more actions than actually killing an individual member of a listed species. So harm and harass both protect against interference with a species' essential like functions, including feeding. So if an oyster farm is affecting a red knot's feeding behavior, this can be considered a non-lethal take under the Act. So under the ESA, there can be what are known as incidental takings. So an incidental take is any taking otherwise prohibited, and such taking is incidental to and not the purpose of the carrying out of an otherwise lawful activity. In other words, when a legal activity has the unintended consequences of harming a listed species, it is described as an incidental take. Thus, in biological opinions, the agencies can create what are known as incidental take statements, which allow a certain amount of take for the activity at a level that will not jeopardize the species. So the red knot biop contained an incidental take statement that allows the structural aquaculture industry to impact the red knots up to a certain allowable extent. Certain activities that would otherwise make the aquaculture industry liable for takes under Section 9 are allowed under this incidental take statement. So the ICS distinguishes between lethal and non-lethal takes, allowing 315 lethal takes from the harassment or harm of red knots over the 10-year life of the biops. In comparison, the biop does allocate non-lethal takes among certain farms in particular, allocating 644 non-lethal takes to one farm and 641 to another. The aquaculture community has expressed some concern, however, over how these takes will be calculated, in particular because for actions that are not covered by the incidental take statement, the farmers could be liable for a take, even if the take was incidental to the day-to-day operations of the farm. This means the farmers could be liable for penalties under Section 10 of the ESA, and civil penalties range anywhere from $500 to $25,000, while criminal penalties can be up to $50,000 or a year in prison. However, depending on the nature of the violation, the actual penalty in the case could be significantly less because the government has significant enforcement discretion in setting these penalties. So just to wrap up, I just wanted to touch on this adaptive management process that has been going on since the biop was finalized back in 2016. So the adaptive management process was provided for under the red knot biop. It's been implemented by an agency working group, which then created a stakeholder committee, which includes members of both the aquaculture community and the red knot community. And it holds joint meetings of both groups at least annually. And this process allows the conservation measures to be adjusted based on new data or review of existing data. But it's not mandatory to change the conservation measures. This is a discretionary process. So it's not that if new data comes out, they have to be changed. But the conservation measures can be adjusted if the changes will reduce adverse effects to the red knots, benefit the aquaculture industry without increasing adverse effects to red knots, or both. And so looking forward, research continues to be done on the effects of aquaculture on red knots, especially in regards to this adaptive management process. So for example, the effects of oyster rats on the ability of horseshoe crabs to come ashore and lay eggs is the basis of continuing studies. And there have been conservation measure changes during this adaptive management process. Some recent changes include allowing vehicle use and intertidal access for additional each year, increasing boat access, and then allowing operations to phase into lake height requirements. So with that, I'll wrap up and get to questions or comments that we have to presentation.
Great. So thanks, Amanda and Kathy, for the presentation. We'll just give folks a minute or two to see if there's questions. You may use the chat function to ask any of the speakers if they have questions. And while you're thinking about your questions, if you have any, we just wanted to do a quick promo for the upcoming webinars in the series. These will all be on Wednesdays from 2 to 3 p.m. Eastern Time. So the next one is July 31st, which will be a presentation with focusing on the evolving regulatory structure for shellfish aquaculture. The first part of the presentation will be on the case study in Georgia and their new legislation that was just recently passed, but there will also be some information about new legislation in other states as well. And then we have 3 in August relating to operational limitations on August 14th. And by this, we mean these are things that might come up after the operation has received their license and their permit. So these are things that are coming up when they're actually doing the aquaculture activities themselves. And then on August 21st, the case study about certification of shellfish growing waters in the EEZ, and then we'll wrap up on August 28th with permitting and use conflicts with a case study out of Virginia. It looks like we don't have any questions coming in, and so I did note in the chat box that we have recorded a webinar, and we will be posting it on our website later this week. So if you have anybody that didn't get a chance to join us, or if you joined a little late, we'll be making it available. And so once again, thank you so much for joining us today, and feel free to reach out to myself or any of our presenters by email if you have questions. Thank you.